well. And we have Mr. Kirkpatrick. I see you here. Good morning, sir. And then we have Mr. Boggs as well. All right, gentlemen, just to remind you, 20 minutes allotted apiece. Mr. Kirkpatrick, if you wish to reserve up to 5 minutes for rebuttal. One request: when Mr. Kirkpatrick begins his argument, Mr. Boggs, I'm going to ask you to mute your microphone, okay? Very good. All right, Mr. Kirkpatrick, you may proceed, sir.
Thank you, Your Honor. May it please the court. I represent Mary Ann McCandless, formerly known as Mary Ann Lifsey, and John Shepard in their wearing their hats or in their capacities as the trustees of the Julian H. Lifsey Jr. Revocable Trust of 1988, as amended. This is a petition for a writ of certiorari.
And before you proceed, Mr. Kirkpatrick, do you wish to reserve any time for rebuttal?
Your Honor, thank you for the reminder. Yes, I do. I would like to reserve 5 minutes, please.
Very good. Thank you, sir.
Okay, sorry about that.
That's okay.
This is a petition for a writ of certiorari. As this court is well aware, that written question serves an important function as to halt a miscarriage of justice and as a safety net to keep that from occurring. In this particular case, the record before Your Honors, the complaint as well as the amended complaint is before Your Honor. Our initial brief went through the allegations of the initial complaint, and for just to boil it down and to summarize, this is a case from Trust 4, a subtrust created under the Julian H. Lifsey Jr. Revocable Trust of 1988 against Trust 3, another subtrust of the Julian H. Lifsey Jr. Revocable Trust of 1988. The pleadings, and as I said, our initial brief spent a number of pages going through and pointing out how the parties, if you will, the defendants in this case, are Mary Ann McCandless, formerly Lifsey, and John Shepard as trustees of Trust 3. The primary focus of this petition and our primary argument that we spent the most time in the briefing is that there is no jurisdiction with the underlying trial court over Mary Ann McCandless and John Shepard as the trustees of the Julian H. Lifsey Jr. Revocable Trust of 1988.
May I ask you a question, Mr. Kirkpatrick? As
Yes,
I
sir.
understand the judge's order, he was concerned with some of the allegations that were made. And didn't he at one point said, I don't know what's going on, so let's do this. I need to make sure, I want to see an accounting of all the things, because there had been presented to him that a lot of these trusts, yes, they're distinct, but somehow they do relate. And so there were some, based on what was presented to him, he finally said, you know what, I just need to know what's going on. And by ordering an accounting of everything, wouldn't you say that the trustees, by virtue of their involvement, everything else, that the court does have jurisdiction over everyone?
Your Honor, I disagree with that, as our brief disagrees with that, because we've cited a number of cases that in a trust contest or in any contest where you have different hats being worn, using the opposing party's analogy, that you have to have proper service with that hat. So, and to kind of illustrate it more, in this particular case, Julian H. Lifsey Jr. created his revocable trust of 1988. In that trust, he was the trustee of it. He put in provisions that while living, that there would be an accounting if he requested one, because it was his trust and he was the trustee. Then upon his death, the trust is very clear that 4 sub-trusts created. Trust 1 is for his son, Stanford Lifsey.
Can I pause you just for a second, Mr. Kirkpatrick? Because I've heard this term used a couple of times, and I want to make sure. I don't profess to be an expert in trust by any stretch, but is the Florida statutes that govern trusts, do they recognize a thing called a sub-trust, or is that just nomenclature you all are using to refer to what are separate trusts but are ultimately funded by another trust?
Your Honor, I don't believe subtrust is used in the Florida Trust Code.
Okay,
but
so this is just convenient reference to what these trusts 1 through 4 are. It has no separate legal significance. It's just a convenient way of referencing separate trusts that are ultimately funded by the original trust that started the whole thing.
I would agree somewhat with Your Honor if I understand your question and your comment that the subtrust here are trusts separate on their own. That according to
Right.
Mr. Lifsey's trust agreement, upon his death, these 4 subtrusts were created, and he actually put in how they were supposed to be funded from the big trust. So in this particular scenario, as I was saying, Trust 1 is for his son Stanford and his issue. Trust 2 is for his son Conrad and his issue. Trust 3 is the marital trust, and significant for purposes somewhat in this case, that Trust 3 got everything other than what was carved out in by Mr. Lifsey in his trust that was supposed to go to Trust 1, 2, and 4. And then finally 4 got certain amounts of assets funded to his daughter, who was a Costas member at the time, and her issue. And as I said, Trust 3 gets everything else. And it was very specific in his trust as to what went to Trust 1, Trust 2, and Trust 4, meaning a part of the Crawdaddy's lease, a 25% of a $2 million devise or bequest or gift or distribution for Trust 1. Trust 2 essentially got the same, and Trust 4 for the daughter got 50% of the Crawdaddy's lease, and then 50% of the $2 million. And again, what's significant is here that Trust 3, the marital trust, if you will, got everything else, including it received everything that was supposed to come in from the probate of his estate, meaning whatever assets that he held individually that weren't in the trust eventually flow into Trust 3 also.
And if I understand the particular issue you're arguing about, as far as, whatever happened. I think the discrete issue and the only thing we have to worry about in this appeal is your argument that, look, these folks, my clients, McCandless and Shepard, are indeed trustees of the first, we'll call it the master trust. They're also trustees of trust number 3. The operative pleading here only references trust number 3. It only references them vis-a-vis trust 3. We showed up to a hearing, and on a claim that has yet to even be answered, an accounting claim, somehow the circuit court granted the ultimate relief sought as in a different capacity than what they have. My question is that seems to be a complaint about the grant, what would arguably be the premature or improper granting of an accounting. You're here on a writ of certiorari, though. Are you aware, and I did a little look and I couldn't find anything, but are you aware of any case law that addresses this kind of unique claim of an accounting vis-a-vis the grant of an extraordinary writ? In other words, if Mr. Boggs were to get up in his time and say, hey, look, it's just an accounting, they have to do it anyways. And at the end of the day, if we're wrong, we're wrong, but at least we'll know. I could imagine that being an argument that a lawyer might wish to make. What would your response be insofar as you are here on an extraordinary writ?
Yes, Your Honor. I don't have a case regarding an accounting. We searched for it. There wasn't a case from that, but we did cite a case in our brief in terms of where there's jurisdiction lacking. And we cited a whole host of cases where if you're going to sue the trustees of the big trust, if you will, and seek an accounting, then you need to do that. And there needs to be pleadings to that effect and an answer to it, and therefore pleadings. And so the court can invoke jurisdiction in order to have the power to order the accounting in question.
And if I'm going to go with that jurisdictional argument, Mr. Kirkpatrick, I think that necessarily requires us to kind of unwind the ball a little bit of, okay, well, what is the legal entity of a trust? I mean, they have sued McCandless and Shepard. McCandless and Shepard are properly before the court, and they've not argued about, at least not to my knowledge, they've not argued lack of personal jurisdiction. The question here is really their capacity. In which capacity are they being sued?
Yes, sir.
You're making the argument that it is because the relief here relates to the master trust. This is a completely different entity than
Correct.
the entity of the trust 3. And I'm not sure that Florida law has ever quite been that granular or discrete about what the nature of a trust is. So help walk me through that analytical underpinning that seems to relate to your argument.
Well, sure, Your Honor. First of all, as the record before the court shows, is that the summons was issued to Mary Ann McCandless and John Shepard. And the complaint, the pleadings, if you will, sue them as trustees of T3.
Right.
There's nothing in the complaint, anywhere in the complaint, that sues them as trustees of the 1988 trust, if you will.
I don't disagree. I read the whole thing, and you're right. It's in there.
And it made me feel like, Judge Lucas, that I'm taking a step back, but on your accounting argument or question that you asked, if you look at the accounting count, the accounting is for trust 3.
Right.
The accounting is not for the big trust. And so from day one, when we walked into this hearing back in September, based on the July 5th order, we raised that issue that Judge, unfortunately, with all due respect to the trial court, the trustees of the big trust are not before Your Honor. You have to, if they want to amend, then we have to go down that process and things of that nature. Just because the court is curious or wants to know what happened with a big trust doesn't all of a sudden mean that we throw out the underpinnings of judicial power. I mean, judicial power is based on jurisdiction, and is based, and for purposes of this trust, if to take your question to the logical conclusion that if the big trust is always involved, because the subtrust or these individual trusts are involved, that means trust 1 and trust 2 are also involved. That if you're going to count the trust as all of the trusts together, which I would argue that the pleadings then don't even state a cause of action, because the pleadings in this case, the parties are clear that it's the trustees of trust 4 versus the trustees of trust 3. That's the cause of action. And Your Honor's point is well taken, that had the court entered an order here that says, okay, trustees of trust 3, you're going to provide an accounting to trust 4, then that's a summary judgment claim that has to go through a summary judgment. And the law is pretty clear on that you don't just automatically get an accounting without having a full evidentiary hearing and a trial on the merits. And that's what I understood Your Honor was asking about. But we cited a number of cases in our brief on that capacity, or the hats that somebody is wearing, is very important. We had a divorce case where somebody was, said that the husband, because he had been, served with it, it also involved his related entities without them being pulled into a particular provision. You have, trustees. At one point, these trustees were trustees of a number of different trusts that were created there and involving other trusts. If we don't hold to the jurisdiction and the tenet that the Lovett case, the Supreme Court of Florida said a long time ago in 1927, that without jurisdiction, the court is powerless, then capacity means nothing. And we're sending all these trustee cases where you have multiple trustees, you have the same trustees over multiple trusts into disarray, because you'd have a motion to dismiss every time saying, we don't know where we're being sued, even though your caption, not that caption, rules the day. The style of the case says we're suing them as trustees of trust number 3. And even though the body of the complaint, as Your Honor said, you've looked at it, doesn't talk about a accounting or any claims being made against the trust of 1988.
So, Mr. Patrick, I know you could keep on going. I wanted to let you know that you are approaching your 5-minute rebuttal.
Okay, Your Honor, Your Honors, I'll just state that the facts are pretty clear. That I believe my esteemed opponent can't show where the 1988 trust has in fact been sued. Instead, the 1988 trust, any provisions in the complaint before the court only mentioned that it creates the subtrust in question, doesn't bring those trustees into play. And Your Honor, therefore, the order that was entered in question, found at App A367, says the court finds that the trustees of the Julian H. Livesey Revocable Trust of 1988, as amended, i.e. the trust, should provide a final accounting on that trust. And Your Honor, it's clear, the record's clear, Your Honors, that at no point have the trustees of the Julian H. Livesey Revocable Trust of 1988 been sued. We also raised the issues of the question of whether or not accounting of the Revocable Trust of 1988 is even provided in the language. That's in the second part of our brief. And the third is the raised judicata. And if Mr. Boggs deals with it on rebuttal or on his answer, I'll deal with it in my rebuttal. Thank you for your time.
Thank you. So you have 4 minutes for rebuttal, sir.
Thank you, ma'am.
All right. Mr. Boggs, we're ready for your argument, sir.
Good morning, Your Honors. May it please the court. I'm David Boggs. I represent the respondents in this case. They are the trustees of the subtrust number 4 under the revocable trust created by Julian Livesey. And we're here today, as has been pointed out, not on an appeal. We're here today on a writ. We're here today because 2 individuals, the defendants below, the petitioners here, were served individually. They were sued individually. And they appeared in a court of equity, which is what the lower court was and is, because it involves trust. This is not a case involving a car accident. It's not a case involving a corporate breach of contract.
Mr. Boggs, I mean, the fact that the court is sitting in chancery or in equity, it doesn't mean that the rules of procedure go by the wayside. You all were able to obtain what is effectively a judgment on your count 11 against these individuals, arguably in a different capacity than what you pled. You received the ultimate relief you sought in count 11 without there ever having been filed an answer or the motion to dismiss heard, and you got that adjudication on a motion to compel. There are a number of troubling things about how that procedure played out and the relief that you got and what is now being challenged. So I'm curious as to your thoughts as to the propriety of how the trial court even could take up this issue of an accounting on a motion to compel.
Yes, Your Honor. The 2 individuals who are the petitioners were sued individually. There were claims made against them. There is personal jurisdiction. There were fraud claims. There was unjust enrichment. There are other claims. The standard is, as to having personal jurisdiction over the person, that there be claims made against them. They were named in the style of the case, and there were claims made. We filed a motion. Judge Barbas was sitting in a court of equity, and in a court of equity, the court cannot turn a blind eye to what it sees as violations of the common law, which still applies. The Florida statutes on trust law are there, but they specifically state in the statute that the common law still applies, and this court has so held previously. Once Judge Barbas understood that he could not understand what was going on here, he had a duty, an obligation to act.
He
That's
had a
what-
duty to dispense with due process requirements of having the pleadings joined, of allowing the other side to file an answer, of having notice that you're going to have an evidentiary hearing on what is effectively count 11. We can just jump through all that, get rid of it, don't need to worry about it because it's a court of equity. It seems a tad of a stretch.
Your Honor, we invoked the Florida statute in the first count, I believe it is, that says that we can ask questions and the court must answer the questions, and we can raise those questions about a trust concerning any trust.
And that's fine for your count 1, the action for section 736.0201. And I don't think that's really what was ordered here. What was ordered here was an accounting, which was the subject of your count 11. And it was ordered, you got the final relief and then some that what you pled for on a motion to compel. That is what is troubling me. I understand it's a court of equity. There's no question that that's the case. The procedure though here is what I'm concerned with, is that you all got your ultimate relief in count 11. You got it against these individuals. You got it against them arguably in a different capacity. And there's never even been an answer filed on that. There was no motion for summary judgment, no notice of trial. You got it in a motion to compel. Help me get past explain to me why that shouldn't matter, why I should not concern myself with that.
Because, I have to go back to what I've been saying, Your Honor. As a trust lawyer for many decades, trust law and trust courts operate in a much broader, expansive reach than do regular circuit court proceedings. Once you have jurisdiction over a person, if that person is in front of a judge in a court of equity, and that judge determines that equity is being violated, the Florida Supreme Court has repeatedly said that the courts of equity are to protect the wards of equity, the beneficiaries of the trust. And the Judge Barbas, could not turn a blind eye to that. He clearly said, and we've cited this, and it's been cited here this morning, that Judge Barbas said, I can't tell what's going on here until I know what went on with the master trust, the revocable trust. There's only one trust agreement here. It's the only exhibit. Exhibit A to the complaint, the amended complaint, is the revocable trust agreement. That's the only trust agreement here. It covers everything. And it has in it an accounting requirement that is, in my experience, something I've never seen. It's an accounting requirement that requires the trustees of the revocable trust, who happen to be these same two individuals, it requires them to account for all 5 trusts until the last one ceases to exist. So there was no surprise here. These individuals act like, oh, we're surprised that we walked in and we violated our duties for 30 plus years. And we walk in and a judge says, wait a minute, I can't even figure out what's going on here. I have to order this.
Well, I'll play devil's advocate, Mr. Boggs. I suspect that what your friend on the other side will say is, no, the surprise was we walked in for a motion to compel hearing, and next thing we knew, no, we're ordered to afford relief on their count 11 that we haven't even answered.
Well, Your Honor, the motion made clear what we were asking for, and we were asking for exactly what got ordered here. So it's not like they walked into a hearing and something was different than what was in the motion. They had a motion, they had notice, they had a hearing, they had filings after the hearing.
Yeah.
They've had plenty of due process here. And my clients who are beneficiaries also are entitled to due process under equity to have what is required to be done for them. The judge in this case acted no differently really than like a probate judge, because that's also a court of equity. And there's an expansive operation of our probate courts. It happens every day in this state. There are motions filed, there are orders entered, there are things required to be done. What these people were, the petitioners were required to do here was not something new. Judge Barbas did not create a new obligation. This one existed before this suit was even filed, before there was a motion and before there was a hearing. So as a writ, there are things that have to be established in the pleadings by petitioners, and they have totally failed to do the most important of them. And that is they have to establish that there has been a monetary loss. Without establishing a monetary loss, the writ has to be denied. If you go back to, we've cited it, go to Harley Shipbuilding from this court, which says there has to be established irreparable harm. That court, Harley Shipbuilding, cited to the Florida Supreme Court decision of Allstate Insurance. There has to be a showing of a material injury. And we cited also the Florida Supreme Court decision of Ivy, which says you have to establish a monetary loss. This court has repeatedly stated that if on a writ, you cannot establish the harm, the monetary loss, the writ must be dismissed, and that is jurisdictional. You have to establish the harm before you establish whether there has been a departure from the essential requirements of law.
I'm not sure I understand your argument about monetary loss. Are you suggesting that certiorari jurisdiction only exists where there is a monetary loss? Are you really arguing that?
That's one of the two requirements.
Because we issue writs of certiorari to prevent cat out of the bag discovery issues that have nothing to do, necessarily anything to do with money, have to do with just breaching confidentiality.
What I'm saying, Your Honor, is the petitioners, under the long established rules for certiorari, have to establish two things. They have to establish a departure from the essential requirements of law, and they have to establish a monetary loss. That's what the rules are.
I'll confess that's a novel view. I hadn't heard that argued before.
Well, the High Five Products Inc. Decision of this court in December 13th, 2019, dismissing a case on a certiorari review because that was not established, citing to the Barker case of this court from 2005. There are many cases. There are two requirements that have to be established, and the entire coverage of the petition and the reply by petitioners only went to the one requirement. They've totally failed to state, has failed to establish, failed to do anything on the second point, which is considered the most important one by the court decisions, and that is to show irreparable harm. And since they have not pled it, then they have conceded it doesn't exist. So the case here, there are a number of counts in the case. It's not just the accounting count, there's a commingling count. And it's been admitted that there's commingling here. When you have commingling of a trust, a master trust, 4 sub-trusts with a trust agreement accounting requirement for an overall accounting, a unified accounting, it was totally within the authority and right of Judge Barbas to enter the order he entered. Once you commingle everything, you have wrapped one thing into another, and trust courts cannot just sit there and say, okay, I'm going to look the other way. Judge Barbas did not issue a ruling. He did not find that anyone had committed fraud or anything
Help me out,
else.
Mr. Boggs. What is you keep referring to it as a trust court. I mean, this is a circuit civil action where you have pled some claims in an 11 count complaint. You have pled some claims that certainly relate to trust, but you've got an unjust enrichment account, a fraud count, breach of fiduciary count, indemnification. That's all pretty standard circuit civil stuff. I mean, what are you, when you say a trust court, are you saying the fact that this involves a trust changes how the case ought to be processed? Am I understanding that argument?
To a certain extent, yes, Your Honor.
Okay.
The
All right.
courts, the courts have said, and the Florida Supreme Court has said repeatedly, that in all cases involving trusts,
Mhm.
that then the lower court has original, general, and inherent jurisdiction and equity.
Yeah.
That's it. Once you have a trust, once you have a case and it involves trust and it involves the management of trust and the way they were handled, it becomes an equity case. The Supreme Court has also said that the lower courts then have total supervisory power. Supervisory power. That's exactly what Judge Barbas was doing. He was utilizing his supervisory power. And the other thing the Florida Supreme Court has repeatedly said is that as a court of equity, the court of equity can hold trustees responsible for things that they are always accountable. So once these two individuals got brought before Judge Barbas, they were accountable to Judge Barbas. He had total power to do what he did. So unless the court has any further questions for me, which I'm more than happy to try to answer, I would ask that the court consider that the established requirements for certiorari have not been met here in the pleadings. There's been no irreparable harm established. And in fact, there's been no departure from the fundamental requirements of law. Instead, the lower court totally followed the fundamental requirements of law here. And so I would ask that certiorari review that this petition be dismissed.
Very good. Thank you, Mr. Boggs. All right, Mr. Kirkpatrick, you have your 4 minutes for rebuttal, sir.
Your Honor, I appreciate it. What I heard in the reply argument or the rebuttal argument was that somehow there's a special niche for trust cases that are filed. 736-0201 says judicial proceedings concerning the trust shall be commenced by filing a complaint and shall be governed by the Florida Rules of Civil Procedure.
No, and
Jurisdiction.
And if I may, Mr. Kirkpatrick, I understand what you're about to say, but help me out with the issue that I'm struggling with. This is a writ of certiorari. Where is the irreparable harm? I mean, what's the bottom line? So accounting is made. You could raise that issue up on appeal down the road. What makes it so, like at this point in time, the immediacy, the urgency, that's how much your clients are totally, problematic in proceeding through that.
Sure, Your Honor. And while I don't share Mr. Boggs's opinion that for a writ of certiorari, you have to have monetary harm, there is monetary harm in the record with the order itself saying that the trustees, before the court, trustees of Trust 3 have to pay for the accounting, court-ordered accounting of the big trust, which is not before the court. That's the irreparable harm that the that monetary amounts out of Trust 3 is going to pay for an accounting, which is not even requested in the underlying documents. And I, one thing, we cited the Ostrowski case from the 5th DCA for that the improper exercise of jurisdiction over a non-party is reviewable by a writ of cert. So I disagree with Mr. Boggs's conclusion that somehow there has to be a monetary element of it here. But the harm here, Your Honor, is that, again, what Judge Barbas has ordered is an accounting of a trust, the big trust, if you will, that is not before him. The parties to this case are clear that it's the Trust 3, even the accounting issue, which Judge Lucas keeps bringing up as count 11, is an accounting of Trust 3. It's not an accounting of the big trust. Nowhere in the papers, in the pleadings that are before the court, is an accounting of the big trust requested. Nor was there a discovery request asking for an accounting of the big trust. Instead, in lieu or right after the clerk entered an order saying that there a notice of lack of prosecution, we got a motion to compel an accounting of a trust, again, that is not before the So, Your Honor, that's the irreparable harm. And respectfully, Your Honors should be, concerned, or I respectfully ask you to be concerned, as this court was back in 84 Lumber Company versus Cooper, found at 656 Southern 2nd, 1297, 1994 decision for the 2nd DCA. And it focuses on, again, the jurisdiction, because the fundamental nature of jurisdiction, the fundamental nature that arises of jurisdiction arising for purposes of due process, for that there should be a summons issued, there should be a complaint served or a pleading served on the trustees of the big trust, where they have a chance to answer the pleadings from that standpoint and be properly brought before the court, or the court invokes the jurisdiction. Simply naming or attaching the document that creates the separate trust, where you have a trust 4 suing the trust 3, doesn't somehow make the whole trust and open the door for just a motion to compel with no discovery, no notice, no summons, no complaint, and no invocation of jurisdiction. We cited a number of cases to
Mr.
the court.
Mr. Kirkpatrick, if I may, sir, you have exhausted. You hear the bell? You have exhausted your 4 minutes. This is a nifty little timer that I have here.
It is. Your Honors, we would request that the writ be accepted and be issued, and that the underlying case, the underlying order, and all subsequent orders be voided as known.
Thank you, gentlemen, and thank you for appearing.